Welcome to Steno Dictation by PT. 5 seconds. Start. This civil appeal is directed against the judgment and order passed by the High Court of Judicature at Delhi, whereby the learned judge dismissed the second appeal filed by the appellant herein. The facts leading to the present litigation are that the property in question originally belonged to the deceased father of the parties. After the demise of the patriarch, a dispute arose regarding the partition of the ancestral property. The plaintiffs filed a suit for partition and separate possession, claiming a third one share in the scheduled properties. It was contended by the respondents that a family settlement had already taken place during the lifetime of the father, and therefore the suit was not maintainable. The trial court, after examining the oral and documentary evidence, held that the alleged family settlement was not proved in accordance with the law. The learned counsel appearing for the appellant submitted that the courts below failed to appreciate the provisions of the Hindu Succession Act. It was argued that the amendment of 2005 granted equal rights to daughters in the corpuscenary property. The appellant sought a declaration that the registered sale deed executed by the brother in favor of a third party was null and void. On the other hand, the respondents argued that the property was self-acquired and not ancestral. They relied upon a will alleged to have been executed by the father in the year 1995. However, the execution of the will was surrounded by suspicious circumstances. The attesting witnesses were not produced before the court, and the signature of the testator was disputed by the forensic experts. In the light of these submissions, the primary question for our consideration is whether the property can be treated as a joint family property. Under the Indian Evidence Act, the burden of proof lies on the person who asserts the existence of a particular fact. In the present case, the respondents failed to prove the validity of the will beyond reasonable doubt. It is a settled principle of law that a person claiming under a will must remove all suspicious circumstances to the satisfaction of the court. Furthermore, the registration of a document does not by itself dispense with the recruitment of proving its execution. The High Court, in the impugned judgment, overlooked the vital admissions made by the witnesses during the cross examination. We find that the findings of the courts below are perverse and contrary to the material on record. The doctrine of res sub judice was also invoked by the learned counsel for the respondents, stating that a previous suit regarding the same subject matter was pending. However, we find that the parties and the cause of action in the earlier litigation were distinct. The principles of natural justice require that every party must be given a fair opportunity to present their case. The non-examination of the material witnesses has resulted in a miscarriage of justice. It is also observed that the lower courts did not pass any interim injunction to protect the property from being alienated during the pendency of the suit. This has led to the creation of third party interests, which further complicates the decree of partition. Having carefully considered the rival contentions, we are of the view that the appellant is entitled to a share in the properties. The Hindu Succession Amendment Act 2005 has a retrospective effect in terms of the rights of the daughter. The judgment of the High Court is therefore set aside. We direct the trial court to appoint a court commissioner for the purpose of carrying out the partition by metes and bounds. The interim stay granted by this court shall continue until the final decree is passed. The appeal is allowed with no order as to costs. All pending applications stand disposed of.